Subject: Law of Criminal Procedure. Topic: Where crime is tried, territorial jurisdiction, and cognizance. Namaste and welcome back. In this third lecture of our series, we're going to explore the critical rules that govern exactly where a case belongs and how a court officially begins its work. Let's get started. To give you a clear roadmap of our explainer today, we're examining chapters 13 and 14 of the Bharatiya Nyayik Suraksha Sanhita, or the BNSS. We'll start with territorial jurisdiction basics, move right through the exceptions for complex crimes, explore the vital process of cognizance, discuss the rules for committal to the Sessions Court, and then wrap it all up with a summary. Section 1. Territorial Jurisdiction Basics. The fundamental rule of location. Before we can even talk about a trial, we have to establish the baseline for where it actually takes place. Which brings us to the core procedural question of today's explainer. When a crime is committed, which specific court has the authority to try the offender? I know it sounds super straightforward, but in practice, establishing this authority, known as territorial jurisdiction, is the absolute bedrock of a valid legal proceeding. It's literally the foundation. The baseline rule is incredibly simple, and it's found right in Section 177 of the BNSS. Every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction the offense was committed. Practically speaking, if a crime occurs in Pune, Pune courts have jurisdiction. This ensures fairness, and it keeps the trial close to where the evidence and the witnesses actually are. But real life rarely respects local borders. What if a thief steals a car in Pune but is caught driving it through Mumbai? Or what if a cybercrime makes it practically impossible to know exactly where the offense was technically committed? We aren't always left with neat geographic lines. Section 2. Exceptions for complex crimes. Navigating uncertain boundaries. When those geographic lines get blurry, the BNSS steps in with a series of exceptions designed to handle these exact complexities. The law brilliantly prevents cases from falling through the cracks here. Under Section 178, if the exact location of a crime is uncertain across several areas, any court having jurisdiction over any of those areas can step up and try the case. Section 179 dictates that if a crime spans multiple local areas, either court has jurisdiction. And crucially, under Section 181, for a continuing offense, imagine a kidnapping that starts in Pune and ends in Mumbai, the trial can happen anywhere the victim was taken, held, or concealed. No technical loopholes, no escaping justice on a geography technicality. Section 3. The process of cognizance. Opening the judicial gates. Okay, so now that we have our location dialed in and know which court has jurisdiction, how does that court actually start the case? This happens through the process of taking cognizance, which is governed by Section 190 of the BNSS. In plain English, taking cognizance means a magistrate formally applies their mind to the facts of a case and decides there is enough evidence to proceed. The magistrate is the ultimate judicial gatekeeper. Without their green light, the entire legal machinery stands completely still. A judicial magistrate of the first class or an empowered second-class magistrate can unlock these judicial gates in three distinct ways. First, through a private citizen's complaint under Section 190 Clause A. Second, and most commonly, acting upon a police report. This is the formal charge sheet submitted after an investigation under Clause B. Finally, under Clause C, a magistrate can act sua sponte, meaning on their own initiative, based on their own knowledge or information received from a non-police source. They have immense proactive power to get things moving. Section 4. Committal to Sessions Court. Passing the baton for serious offenses. But what happens when a crime is so severe that it completely exceeds the trial authority of the magistrate who just opened the gates? Certain severe offenses, like murder or dacoity, belong exclusively in the higher court of session. However, the court of session cannot simply open its own doors and take direct cognizance. The case must first go to a judicial magistrate to take cognizance in Step 1. Only then, under Section 193, does the magistrate formally commit or transfer the case up to the court of session. The magistrate acts as the mandatory, inescapable gateway to the higher courts before that trial can ever begin. Section 5. Summary and next steps. Recapping our journey. We've covered some foundational ground today, so let's recap to ensure these critical concepts are locked in. To summarize, territorial jurisdiction usually follows the exact location of the crime under Section 177, but Sections 178 through 183 provide foolproof exceptions for blurry borders and continuing offenses. We also saw how magistrates initiate trials by taking cognizance under Section 190, acting on police reports, private complaints, or their own knowledge. And finally, we learned how they must pass serious offenses up to the Court of Session under Section 193.
Consider this. If these strict rules dictating exactly where a trial takes place didn't exist, how easy would it be for the wealthy and powerful to manipulate the justice system simply by moving a case across state lines to a more favorable court? Jurisdiction ensures fairness. In our next explainer, we will explore the First Information Report, the FIR, the new rules for electronic FIRs, and the strict rules governing when and how a police officer can arrest a suspect. Thank you for studying with me today. I will see you in the next lecture.